Welcome.
Thank you. Thank you very much. So I don't do a presentation on a specific topic because I find that I don't want to dull you guys with regard to a specific issue. I kind of treat these presentations as a consultation where you guys just give me a series of questions. I'll answer them to the best of my ability. I'd like to address Mr. Bondi's question first because, like I said, it's a little convoluted, and I'm trying to get an idea because you raised 3 separate issues that I want to kind of clarify on. I want to answer your questions. I believe I can answer your questions, but I just want to. You say that if there is a signed lease with an expiry date of the lease, does the buyer have the right to stay on when the landlord wants the place for his own personal use? So what is the question? They have a signed lease with an expiry date. So typically we have a 12-month lease and there's an expiration date on that lease. For clarity for everyone, a lease does not expire, so to speak. It never goes away. The term, the 12-month term goes, but the lease itself remains in existence for the entirety of the tenancy. So your question based on that.
How long does the tenancy have to last?
It lasts until both the landlord and the tenant agree that the tenancy no longer remains. A tenant, once the term ends, it goes into a month-to-month lease, and they have to give at least 60 days written notice. And there's a form for that. It's an N9 notice for a tenant to terminate their tenancy. Or there's what's called an N11 notice, and an N11 notice is simply a landlord and a tenant both agree to terminate the tenancy on a certain date.
Is there any way the landlord can terminate the tenancy?
They have to have a reason. What's the reason? That's not a reason. Remember, the lease itself continues on month to month.
So November 1st, for the following year, November 1st.
No, it's actually just for, no, but I want, before you move forward with your question, one thing, and I see this, I deal with a lot of you guys. I fix a lot of the problems that come about when things are not done right. They're not written in the proper format. So if you want rent to be paid on the first of the month, then it goes from the first of the month. If it's a year lease, let's say it's August 1st is your commencement, it would be July 31st is the last day. And that's a year lease. Okay, go ahead.
So that tenant can still remain there?
Correct.
Okay, so they're not right. They don't want to, what can the landlord do?
They have to have a reason. Is the tenant paying rent? Is the tenant stop paying rent? Are they persistently late? Does the landlord want to renovate the property for, and we can address if anybody has questions about renovations. We call them renovictions. I'm not a big fan. I represent both landlords and tenants, so I'm not a big fan of renovictions. I don't think I don't think it's fair in many cases. I'll be quite frank, I think a lot of landlords, not the majority, but there's a number of landlords out there that take advantage of these types of processes. So.
If it's month to month afterwards, after the term is done, the tenant can leave with 60 days notice or 30 days?
60 days notice.
Okay.
60 days. Has to be written. It should be on an N9 notice if they want to terminate, but it's not necessary. It's not required. I can actually, if a tenant were to give me an N9 notice or a text message saying that they're vacating the rental unit, I can take that text message and I can literally file an application with the board. It's an L3 application that allows me to use that text message as a notice of termination, and the board will issue an order for termination of the tenancy for that specific date.
Okay.
Yes, it is a reason. Yes, but here's a caveat to that. If they want to sell the property, they have to have 1, a signed purchase agreement. Number 2, in your schedule, what's it called, with your conditions, it has to be written that the land or the purchaser will be moving into the rental unit. And here's the kicker for that. and this recently was adjudicated in Ontario, in the Superior Court of Justice on an appeal. If the purchaser does not move into the rental unit, they become liable for any damages. So they're required to be there for a minimum of 12 months. A tenant can bring an application to the board that the purchaser did not move into the rental unit, and as a result of that, they can incur damages. They can be fined up to $50,000. The tenant has the right to, if their rent went from $1,500 to $2,500, they're entitled to $1,000 additional month for a minimum of 12 months. So they would be entitled to $12,000. I just had 2 cases like that just this past February, where I got a $17,000 judgment against the landlord, and they were fined $10,000 because the purchaser decided 3 days after closing to list the property for sale to make a $50,000. They just flipped the house. In Windsor. Yeah.
The buyer is responsible. Does the
No.
owner have any responsibility there? In that circumstance?
Yes and no. Yes and no. And here's the situation: is that when a tenant files an application based on a bad faith notice, they're required in the application to name both the former landlord and the new landlord, or the new owner. And the reason why is because when you go to court and you present your case, if the old former landlord was aware of this conduct, then they both become liable to it.
How do you prove you're not aware, though, as the seller of the property? You have no control over the buyer's actions.
Well, that's for a court to decide. Yeah. Just hold on.
So there's a clause that we have, or do you have something better than, kind of, we've got one that says, seller, like mainly the buyer of the property is purchasing the property, and they will be moving in themselves, or a family member will be moving in, and if that does not happen, then the liability is on them, and the seller takes on no liability for that.
That's what we just talked about. When the tenant,
There's a clause for that,
there's a clause.
that we put in our agreement. of
No, I
rental
knew that. I
sales.
know that. And most of you agents do put that clause in there. It's just that when a tenant raises an application, they are required to name both the seller as well as the buyer in their application.
Right, but what
'Cause
if that goes to court, that clause there would protect our sellers from?
Yes, it could, but in that application that I just talked about, where I got that judgment of $17,000 and a $10,000 fine, the real estate agent of the buyer told the court that the seller was aware of what they were doing. Now, on a balance of probabilities, they wanted to throw them under the bus, essentially. But on a balance of probabilities, their agent essentially convinced the court that that was not the case, and that the agent was just trying to point blame somewhere else. Yes, go ahead.
I have a deal like that right now where the purchaser is going to be moving into the unit, so the tenant's been given their 60 days notice. Now, what happens at the end of the 60 days? He'll get ready to close, and in that instance, the tenant's going to vacate. Does it have to go to a hearing like it would otherwise?
So that's a good point, and you're going to find that a lot of your sellers, most of your sellers, they don't want to spend the money to file an application with the board. I can't stress this enough, you need to file your application. Once that notice has been served, compensation has been made, you need to file that application. Because if the tenant does not move out by that termination date, if you look at an N12 notice, you look at the second page, I think it's paragraph 6, it says, what if you disagree with this notice? It's a notice to the tenant, what if you disagree? It literally states, you do not have to move out by the termination date as set out in this notice. However, your landlord can file an application to terminate your tenancy, all right? This assures you, number one, if you got a closing date, let's say, when you serve the notice, you got a closing date, let's say 90 days away, that it's gonna take you at least 2 to 4 months to get a hearing date, all right? If you wait until after that termination date to file your application, then you've wasted 2 months of your time waiting for a hearing date.
I mean, that call's been filed, submitted. I'm just saying, now that everything's lined up, if closing date comes up, and the tenant says I'm not moving,
No,
Is it cut and dry, okay, sheriff comes out? or
no,
it has
you have to
go
get a
to
court order. You have to get a court order. They're essentially saying they're disagreeing with that notice if they don't leave by that date. So start the process.
Right now, they're saying already,
Start the process.
but more than that, well, that's already done.
Start the process. I'm just, I can't stress this enough. You guys want to protect your asses? Start the process. Look, if the tenant moves out, great. You know what? You don't have to go to a hearing date, right? But if you don't start the process and the tenant does decides at the last minute, and I've seen this more times than not, that they'll say, oh, we couldn't find a place. I see you nodding your head all the time back there. File the there's an L2 application needs to be filed with the landlord and tenant board. You're doing your clients an injustice if you don't start the process. Yes.
I have a client who their tenant hasn't paid in over a year.
Well, why haven't they started the process?
They did. They started the process, and it's obviously taken a long time. Now he's still trying to get this tenant out, and he's wanting to sell it. So how does he get? How does he get this guy out of it?
Does he have an open application with the
Yeah,
landlord and tenant
yes.
board? Has it been spoken to yet?
I believe so.
Is there a paralegal or a lawyer on the side of the landlord? My question to them is why haven't they filed a request for an early hearing?
Right? I don't know.
Rental arrears of 12 months, yeah,
Ask for an early hearing.
you can ask, yeah, especially if the application was filed over a year ago. They're trying to clean up their docket. And so they need to, I don't know who the paralegal is, but they need to, again, start a process. Because if the court's not aware of anything, it's not incumbent on the court to deal with it. They're just going to go on their own natural timeline. They need to,
He's definitely started
those
the process,
notices,
but
that motion puts the court on notice, hey, look at me over here.
yeah.
I've been waiting for this for over a year. The client or the tenant continues to not pay rent. I got mortgage that's not being unpaid. I've got potential, I have to consider selling the property.
Right,
There's
yeah.
all kinds of reasons, and that will force the court to make a determination, hey, we need to get this on the early docket.
So we can't have the police, the sheriff come.
Sheriff only enforces court orders. Yes.
Compensation that's due when you serve the 60 days notice, is it permissible to use to skip the next month's rent for that?
You have to put it in writing that you intend on, you don't pay me December's rent, it's gonna be used for your compensation. And so what you do is you print out that email, so when you file your application, you're saying, here's my compensation. I use December's rent as compensation in accordance with the rules.
And what is the name of the application that a tenant files if they feel there was something to that?
It's called a T5 application. All right, go ahead.
You mentioned the use of regulations, now having offer and move back in. and all
Yeah,
of
so-
that, that's happening much anymore.
So with an N13, this is, you guys want to really persuade your landlords that want to do a rent eviction. Again, it's a good faith, bad faith situation. But they're required, once they get a court order that they can get vacant possession of the rental unit for a renovation, they're required to give the tenant first right of refusal. And they're required to do that in writing. And if they don't do that in writing, and let's say the tenant doesn't move in and they rent it out to someone else, that tenant can take them to the board. So, and I love those applications. It's good money for me. I get 30% of whatever the order is, I get 30% of those fees. So I love those files.
So the landlord renovates, was getting $1,200 a month in rent, now wants $1,800 a month in rent. Given the first right of refusal, and they say, no, I don't want $1,800 a month, he's free to go rent to somebody else?
You can't ask your tenant to, and you can't increase the rent above the guidelines. You can ask the board, you have to file an application to increase the rent above the guideline because of that. And it's extremely difficult. That's why I'm saying, you guys, you can try to convince your landlords not to use that process, because again, I love those applications.
I was probably sure about that, right? So if the landlord increases the amount of bedrooms or bathrooms, they can't increase the rent, they'll follow that?
No, they can't, because you haven't increased the actual square footage of the house, right? I do that, I see that a lot. I'll see it where the board looks at it, there's 4 walls. Whatever's inside is within the 4 walls, and unless you're increasing the 4 walls, you haven't given them anything.
If you put mirrors up.
Well, you still haven't done anything. Hold on.
During a 1-year lease term, and gave 60 days notice on 7th month. So he's not fulfilling the 1-year term. What else can anyone do?
Okay, so that's a very good question. I get this a lot. So that you got a 1-year lease and they want to terminate the lease like 6 months into the lease. So what do you do with the rest of the term? So once you've been given that notice, okay, we have what's called a duty to mitigate our damages. Do you know what that means?
Yeah.
Okay, so what the landlord is required to do is once they've been given that notice, they need to do an inspection of the rental unit. They need to, work with the tenant to re-rent the property as soon as possible. They have to show the board, or potentially show the board, that they tried to rent the property out in a reasonable period of time. They can file an application, it's called an L10 application, if the tenant vacates, for any revenue that they've lost. I'm just dealing with one of those this past week where the tenant had like 4 months left in their lease. They vacated. They were able to re-rent it, but they lost a month of rent and the real estate fees. And so they were filing an application to recoup the amount of 1 month's rent as well as the real estate fees to the tune of about $5,000. So, and the reason why you want to do this is because when you file that application for that, the board requires you to show what did you do to mitigate your damages as a result. You can't just sit there and let the place be vacant for the remainder of the lease, because all you're doing is you're just saying, okay, well, I'm going to lose the income because now he's going to be responsible for it, the tenant's going to be responsible for it. Do you have a question? Oh,
If the tenant dies and there's still 6 months left on the lease, what happens then?
it's a tricky question. So if a tenant dies, the landlord needs to take possession of the tenancy within 30 days. And I would argue that the estate would not be responsible for the remainder of the lease. I can't see an adjudicator actually saying that the estate would be responsible for the remainder of the lease. But they have to take possession within 30 days. That's the statute. That's what the statute says.
I read up on that a while ago, and I remember vaguely seeing that address where you can hold them responsible for, and it's some short period of time. I don't remember if it was 60 days or 30 days, but that's what I saw when I looked it up.
I'd have to look that up, but I don't believe that, unfortunately, I had a client of mine that passed away as a tenant a couple years ago, and we have a hearing on that matter in a few weeks, where my client filed 2 tenant applications against the landlord, and during that period, he had passed away. And so what had happened was the estate trustee was his sister and was living with him at the time. She wasn't a tenant, she was just a trustee, but resided as an occupant. So what we did is there was a last month's rent on deposit. What we did is said, look, she's going to stay there until rent's been paid for this month. We've got last month's rent for the following month will be used. And then it'll allow her to stay for 60 days. But you're required to take possession. And the reason why is because if you don't take possession, then again, mitigating your damages, how can you go to the estate if you never took possession in accordance with the statute? Okay? Does someone have a question over here? I thought
You just answered it.
Okay.
So what if you don't do 30 days?
Okay.
A couple years ago, someone I know, they were renting out a house to a lady, and during the tenancy, she had a boyfriend that they didn't know about, and before the end of the tenancy, the tenant moved out, but the boyfriend stayed in. Payments kept being made, there was never anything late, but then when the landlord had to go meet with the tenant, they found the person they rented it to had left, and now there was this other guy there that had been making all the payments. Does that person have a right to be there?
Was the landlord aware of that person and making those payments? So they essentially subletted the unit. Is that what you?
Broke up,
Right,
the girl left, and the guy stayed.
okay. And he wasn't on the lease? Okay. So I'm reading over because someone asked me a similar question here. Ruth Ann Osborne, was that your question?
My question, yeah, the same question.
Yeah, so it's a very interesting question. So, and the reason why is because you cannot tell a tenant that they can't sublease a rental unit. They can only, if they're going to sublease it, they have to sublease it at the same amount of rent, whatever rent is. They can't increase the rent. They can't make a profit off of it, okay? That's number one. Number two is that a landlord cannot deny a sublease. You can't put into your conditions in your lease that you're not allowed to sublease because you are, according to the Residential Tenancies Act, which governs these processes. The problem with a sublease is that if the tenant doesn't advise the landlord that they're subleasing the rental unit to whoever it might be, even if they don't, the landlord can file an application because they've sublet without permission or without asking. The board member is most likely 99% of the time is going to allow that sublease to go forward, as long as the tenant comes and says, yes, I forgot to tell the landlord. As long as the landlord's getting his rent, there's no there there. They're not going to terminate a tenancy, especially in the environment that we live in. We're under a housing crisis here, as you guys all know. And they're not going to terminate tenancies because of a minor issue like that, especially when the act allows a tenant to sublease. Now here, as I say, you can't do it, but the actual tenant has to come to court and advise the court that, yeah, I made a mistake, I didn't advise. You've got a lease that says that she's not on the lease, which is good to have. But if that tenant were to say, I am a tenant, as soon as they utter those words, the police are going to go back and say, okay, this is a landlord-tenant dispute, so you need to file an application, start a process to make a determination on whether the act applies in the situation. Because the Windsor Police, they can only enforce occupants, all right? And if the act does not apply where the tenant has rights or they don't have rights, the board will issue an order that says that this individual is an occupant at this residential complex. Then you can take that order and take it to not the sheriff's office, but the Windsor Police and say, she's an illegal occupant, she's trespassing on my property, she needs to go, and they will physically remove her. But it's a process.
Now, one of the things I was asked with the one girl was, they wanted like a police report, and I was denied a police report. I filled it out, I paid this is chat. I paid the $5, and they told me that I'm not privy to what happens, and I'm not privy to a police report, and it's none of my business.
If you're not in the report, then no, there's no freedom of information with regard to that. They'll give you a report, but everything will be blocked out, so what are they giving you?
Yeah, that was what I got. I was like, what?
There you go. That's what you got, because you're not a party to the action. Yes. I have to wrap this up, guys, because I got 15 minutes to get to
If you
court.
cannot deny a sublease,
Yes.
example, the house is being rented, or let's say an apartment building, units are typically going 1,800 a unit. Mr. Smith has been in there for ages, he's paying 600. So now he's going to sublease to his grandson. Glenn subleases to Glenn. 2 years later, Glenn subleases to Glenn.
You can't do
This
it.
becomes a never-ending $600 tenant or tenants.
So he's changing the sublease to someone else?
You can't deny a sublease.
Right.
Does that mean whoever is in these grandfathered old leases could basically stretch them out forever?
Is the individual still alive?
The first
Yeah.
tenant? No, but if you could sublease, does that matter?
Yeah, it does matter, because once he dies, the residential tenancy that has a specific section in the statute that says that once the tenant dies, you have 30 days to take possession.
Even though he's subleased?
Well, there is no lease anymore because the lease terminates upon death. You understand?
I was just referring to, since you made the statement that you cannot deny a sublease.
You can't deny a sublease, but the tenancy itself terminates when the individual is dead. Last question, I'm sorry, guys.
Okay, we're talking about here, I have to go first. So in terms of sublet, what the act says, and my understanding is, I've read it, it says that you can't arbitrarily deny a sublease. It doesn't say you can't deny it, it says you can't deny it for, without a good reason. But then the act goes further. The act goes further and says, once a landlord denies an application to sublease, and here's my question, am I remembering correctly that the act says the lease becomes null and void?
No, it doesn't. It doesn't. No.
Okay, so we've got the arbitrary thing. And in terms of a new person paying the rent, when I had to go through that, it came to my attention that once a landlord knowingly accepts rent from someone else, then that person becomes the tenant. So I'm just wondering how they didn't know.
Not necessarily. Not necessarily. If it's a sublease, it's a sublease. Where they're getting the monies is not relevant at that point. It's the acceptance of if the subletter says, hey, I want to take possession of this property, then as far as a tenant, then the tenant and landlord relationship has to terminate. So it has to be an agreement between the original tenant and the landlord to terminate the tenancy in order to take possession or to have the new tenant or the subletter become the actual tenant. The only thing the money thing comes into at issue is when you don't have to have a lease to determine whether a tenancy exists or not. As long as there's if there's no lease in place, there's no written lease in place, but there's this agreement, hey, I don't want to sign a lease, and the parties agree not to sign a lease. As soon as that money transaction occurs, then there's a tenancy, landlord-tenant relationship. As long as there's no written lease in place.
Did you happen to address my question before I got here? We're in the Ontario residential lease agreement. It asks for the address of the landlord, and I've had realtors put email addresses in there instead of a physical address under the
You need to put in an actual address. Yeah. Two other things, and I gotta go, but it's 8 minutes to my office, so I've got time. The agreement to lease. Paragraph 12 of the agreement to lease says that there will be a lease to follow. All right, you need to tell your landlords. Spoke to Catherine. Yeah. We talked about this briefly earlier. So when you guys are doing these agreements to lease, you either complete that process for the lease or you advise your landlord that there's a requirement to get them to sign this lease because it says that in the agreement to lease. That agreement to lease is not a lease, and I find a lot of landlords are using your OREA agreement to leases as the lease itself. That agreement to lease becomes an addendum to the lease itself, okay? The last thing was, and I think it was one of your questions actually. On the lease itself, if you're going to help your clients with regards to the lease itself, make sure if this says that notices you can use email by way of serving notice. But checking the box yes is not sufficient. You need to provide the email addresses for both the landlord and the tenant. If you don't, the notices can't be served by way of email. Okay? All right, that's all I've got. Thank you.